Hi, my name is Stephanie Fierro and I'm a partner with J. Wilk. I've been practicing in the Valley for 12 years and my practice focuses on estate planning and probate.
And my name is Lauren Garner. I'm an attorney with J. Wilk and I've been practicing law for over 35 years, 19 of which in the Valley. My area of practice is probate and trust litigation and mediation.
So our goal today on this video is to give you a 30,000-foot view of the probate process. Now there are lots of situations and nuances in this area, and so this is not meant as a substitute for specific legal advice, but our goal is to give you an idea of what you can expect throughout this process. So Lauren, what is the probate process? What is probate?
Probate is, generally speaking, the court process by which assets that are titled in a decedent's name are distributed out to the individuals to whom the decedent has designated in their will, or in the absence of a will, to the heirs at law as set forth in the Arizona statutes.
And so is probate something that's always going to be required?
Not necessarily. If you have planned ahead, your assets may be held in a trust, or they may pass by a beneficiary designation, or there may not be sufficient assets to require a probate and you may be able to distribute them by affidavit.
So it sounds like one of the most important things is, and really it is figuring out what did the person own. It's going to be the personal representative's job, the person that will be named to be in charge of those things, to figure out what the person owned and to actually marshal those assets. So it's important to know who that person is. Now there's two different ways that that can happen, and that depends on whether the person died intestate or testate. So Lauren, maybe you can explain what the difference is between those two things.
Testate means the person died with a will. There are different kinds of wills. There are ones that are typed and prepared by an attorney, and there are various signature and notary requirements and witness requirements. There are also holographic wills that are handwritten by the decedent and signed and dated by them. So you need to make sure that you can find the original will and figure out whether it's a valid will or not. If you die without a will, it's called intestate, and in that circumstance, the Arizona statute set forth the manner in which your assets are distributed, and it is to your family in a descending order of your children, your spouse. If you don't have children or spouse, it can go to your parents, and the statute sets forth where it would go in the absence of those relatives.
So how does a personal representative know necessarily what to do, right? That's the question that would naturally come next. And so it's important for whoever is going to be in charge of those things to know where to look. And so one of the things that we will make sure is appended to this recording is actually a link to some self-service forms with the Maricopa County Superior Court. And we've chosen Maricopa County because that's where we practice, but other jurisdictions may have similar forms. They will help you to orient yourself to the process. But just because you've been designated as the personal representative does not necessarily mean that you have the authority to act. So how would someone go about getting the authority to act as PR, or substitute for personal representative, PR for short?
A personal representative is usually nominated in somebody's will. The will say, you know, at the time of my death, I nominate so-and-so to act as or serve as my personal representative, and sometimes there's an alternate identified if the nominated person is either not available or doesn't wish to serve. If it's an intestate estate without a will, then there's a statute that sets forth the priority of who is allowed to serve. But remember, even if you're nominated in a will as personal representative or you have priority under the statute, you are not actually the personal representative and have no authority to act as the personal representative until you've actually filed with the court to open the probate and the court has entered an order appointing you as the personal representative.
And once you file that appointment or that request to be appointed, there's two avenues in which that will actually occur. There's a difference between informal and formal probate. And those are things that can sometimes trip people up. If you've got all of the documentation necessary, there is no one contesting your appointment that you are aware of, you've got a will that nominates you as the person to serve, or if there's no will, you're the person that has priority under the statute, then you can apply to actually have the court designate you as the personal representative. Now, if there is a will, this is very important that you understand that you have to file the original will. You cannot file a copy in an informal probate. So let's say you're faced with this process and all you can find is a copy. The next question is, what do you do?
Well, the court will accept a copy of the will to open it if you can't find the original, but there are some additional things that you have to represent to the court and affidavits that you have to present affirming that this is a true and correct copy to the best of your knowledge. You're not aware that the original will was ripped up or otherwise revoked, and that this is the will that should be admitted to probate.
So what Lauren just mentioned is that you'll have to actually sign an affidavit, and it's a sworn statement in front of the court. So it's really important that you've undertaken all of the things that you're swearing to in that document and making sure that you're being truthful in that process. Now, overall, what we've just talked about are the two different means by which you may be appointed as the personal representative. One is informal. So if you've got all your ducks in a row, you've got all the documents in place, there's no one that you're aware of that's contesting your authority, you have the original will, you can submit that to the clerk, and the clerk may actually appoint you right there at the desk because they'll have everything that they need to do that. On the other hand, if you cannot locate the will or you only have a copy, then you may have to go through a formal process, which actually requires a hearing, and the judge will actually be the one that appoints you in that process. Now that you've been appointed as the personal representative, and by the way, personal representative is the phrase that's used in Arizona. If you're familiar with the phrase executor, it means the same thing, so it's important that you don't get confused about that. But once you've been appointed as the personal representative, you need to understand that the law requires you to do certain things, and you need to make sure that you're doing them in the time frames allowed. So what is one of the things that people need to be aware of, even just in the actual application process? And what I'm thinking of specifically is bond.
As the personal representative, you are being appointed as a fiduciary, and you have fiduciary obligations. So whether you are appointed as personal representative in an informal process where the clerk is able to effectuate your appointment, or you're appointed in a formal process where you have to simply go to a court hearing and the judge effectuates your appointment, you are still a personal representative with fiduciary duties. One of the considerations when you are appointed is whether or not you have to post a bond as the fiduciary. The bond protects the assets that you are now in charge of. Often, the will waive the bond, so it's not required. The bond is essentially an insurance policy to make sure that you administer the assets appropriately. If the will waives the bond, then bond is not required. Even if the will does not waive the bond, if all of the other parties to the estate agree to waive the bond, then the court will usually do that. If the court does not waive the bond, then the bond is to be posted in an amount that relates to the assets that you have control over. One of the ways to reduce the bond is to restrict your access to that. So for instance, if there's a house or other piece of real property in the estate, the court can restrict the sale of that property in the absence of a court order, and if that's the case and the house is restricted, then you don't have to post for the value of the house. The court can also restrict bank accounts up to a certain point, and you don't have to bond for those assets if they're restricted. You only generally have to bond for the assets that are unrestricted, that you can have access to at any time.
And speaking of assets, one of the personal representative's jobs is to actually make an inventory of those assets, making sure that you understand not only what the essentially market value is of those properties, but what is also a lien against that property. Because we need to know not just the assets, but also the debts and liabilities of the estate. And that inventory needs to be prepared in a timely fashion. It's actually designated by statute how long you have to get that done. And that needs to get distributed to any of the interested parties. Now, that was one of the things that we talked about as we were getting ready for this, is this concept of interested party. So, Lauren, maybe you can explain that.
Stephanie, there are a lot of people who would qualify as interested parties in a probate proceeding. You have the people who may have been named under the will, who are called devisees. You also have, if there isn't a will, you have the heirs at law. You may also have people who are claiming to be heirs or devisees, also creditors, also other people who may have requested notice. So you have to be very careful that all of the interested parties are receiving notice, because if you fail to give everybody proper notice, you may have to go back and start all over again, or you may not be able to proceed with the case. So you need to identify and be very careful with that. And those interested parties are most likely going to be listed in the petitions that you file to initiate the probate proceeding.
And you bring up an important point, and that is notice. These interested parties need to receive notice of the actual proceeding, but then there are going to be other notices that you need to file throughout the process. And as we mentioned, on your inventory, you're figuring out not just what the assets are, but who the creditors are, and those creditors need to get notice that this is going on too. So although probate has kind of a bad reputation, it's really not a significantly burdensome process most of the time, but it has some important features, and dealing with creditors is one of them. Once you've provided the requisite notice required by the personal representative, the creditors have a limited period of time within which to make a claim against the estate. And those claims, if not made, will then be barred from being brought later on, but also can be resolved in the process. And you need to be mindful as the personal representative that you're going to have periods of time, if a claim is made, within which to either allow or disallow that claim. So there's a lot of paperwork to be done in between getting appointed and actually closing the estate, but these are all things that you kind of keep in mind as we go along. So now that we've gotten through the creditor claims period and we've gotten through actually getting appointed and notice to interested parties, what else should people be aware of as a part of this process?
So just as a little bit of clarification, once you're appointed as the personal representative, then your duties start. And one of the first things with regard to creditors is you publish a notice in the newspaper that's published for 3 times, 3 weeks, and it's a notice to all of the creditors, known or unknown. And it basically tells them of the existence of the estate and that they have 4 months to lodge a claim or to present a claim to the personal representative. In addition to that, you have to send an actual notice, mail it to them, to the creditors that you do know about. And they then have 60 days from the date that they receive that notice to lodge a claim. If somebody lodges a claim and you have no reason to object to it, then the claim is allowed. If there's a claim that's presented that you don't agree with, then you can disallow it, and there's a whole procedure for dealing with claims that are disallowed. In addition, you have to prepare an inventory, and the inventory is going to list all of the assets in the estate and the value of those assets, and that inventory is going to be provided to the interested parties. So as you are preparing that inventory, you're also, as the personal representative, supposed to be gathering and taking charge of all of those assets and protecting them. You know, for instance, if there's a house, you need to make sure that the house is adequately protected, and you want to make sure to keep charge and possession of those assets while the estate is being administered.
And then once that has completed, once you know that all of the creditors have been taken care of, the time period for people making claims has expired, and you feel really confident that you're at a good place to be able to distribute the assets, you need to understand that you do have an obligation to do that in a timely and efficient manner. So that's something to keep in mind as well. To Lauren's point, once you've gotten those things taken care of and you've adequately protected the assets and you've made sure that you know who all the creditors are and you feel confident that you've got a handle on the expenses of administration, now it's time to make sure that the distributions are made. And you do have an obligation to do those timely and efficiently. Now, once that is done, you're not done. There are still other things that need to be taken care of, and that includes an actual closing of the probate matter itself. So Lauren, what does that look like?
There are a couple of different ways to close an estate. There's a formal way if you want the court to enter an order and bless the plan of distribution and make it an absolutely final estate with a hearing. You can also close it informally through a closing statement that's simply filed with the court. Either way, as you're making distributions, you want to make sure to get receipts from the beneficiaries or the heirs to whom you're making distributions, and remember not to, or hold off on making the distributions until all of the creditors have been paid. But as Stephanie said, it is important that you do this in a timely, efficient fashion.
So that said, that's something that as we've been talking, we've kind of been assuming that everything's been going smoothly. But we all know that that's not always going to be the case. So what do you think about that, Lauren? I mean, this is really more your area.
And my area of practice is probate and trust litigation. And that is when people are not agreeing. And those disputes can either be with regard to the validity of the will or other estate planning documents, or the disputes can be with regard to the actual administration. Wills are often contested because people claim that the decedent did not have the mental capacity or the testamentary capacity to execute the will, or they were unduly influenced into doing it. As far as administration goes, a lot of times personal representatives are accused of having misadministered the funds, or not have done it in a proper fashion, or not have done it soon enough, and people go after them for either perceived or actual misadventures in probate administration. If you are a beneficiary or an heir, it is very important for you to be patient with the process, but also make sure that you are attentive to it, and if you believe that something is being done incorrectly, that you seek counsel and make sure that you are doing what you need to do to timely enforce your rights as a beneficiary or an heir.
So that concludes our video for today, and we hope you found it informative. Please keep in mind that this was intended to be a broad overview of the probate process and is not necessarily going to guide you through your specific facts and circumstances, but we have some additional information that may help.
The Maricopa County Superior Court has a self-service center that can provide you with all of the necessary probate forms. That link is below.
I'm Stephanie Fiera with J. Berg Wilk.
And I'm Lauren Garner with J. Berg Wilk. Thank you very much.